I am audible, Aishwarya ma'am. Right now I am audible. But I am not able to. Can you speak, ma'am? No. But over here I am not able to. Yeah.
Rajesh sir, you can start now.
So a very good morning to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul University, Vadodara, Gujarat. I warm welcome our two speaker, Honorable Justice A.H.M.T. Nawaz and Advocate Aishwarya Bhati, who is the Additional Solicitor General of India. And Honorable Justice A.H.M.T. Nawaz is a sitting judge of the Sri Lanka Supreme Court. Let me introduce about A.H.M.T. Nawaz. Justice A.H.M.T. Nawaz was sworn in as a judge of the Supreme Court of Sri Lanka on the 1st of December 2020. Prior to his elevation, Justice Nawaz has been functioning as a president of the Court of Appeal of Sri Lanka. Before Justice Nawaz was elevated to the judiciary first as a judge of the Court of Appeal in 2014. And he has been long serving in the Attorney General's office in Sri Lanka as the State Counsel, Senior State Counsel, and Deputy Solicitor General of India, General of Sri Lanka. In the year 2005, when he was serving as a senior prosecutor in the Attorney General office, Justice Nawaz won the prestigious British Chevening Evening Scholarship Award by the Foreign and Commonwealth Office of the United Kingdom and pursued his LLM, that is the Master of Law, in the Commercial and Corporate Law at the King's Law College, London. In the year 2008, he won the Fulbright Humphrey Fellowship awarded by the US government and pursued his second LLM in the Transitional Criminal and the Commercial Law at Washington College of the Law, American University. Furthermore, whilst the Fulbright Humphrey Fellowship, Justice Nawaz worked as a foreign attorney at the global law firms such as Arnold, Porter LLP, Square, Center, Dempsey LLP, and vigorously took part in the arbitration and the world trade law practice of the two American law firms. Justice Nawaz also secured a third Master of the Law in the Constitutional Law and Administrative Law for the Faculty of the Law of the University of Colombo. Justice Nawaz, whilst serving in the Attorney General Department, extensively appeared for the both domestic and international arbitrators and later lectured arbitration both in the domestic and overseas students. He holds an LLB degree from the University of Colombo and is second master at the Washington College of the Law, American University, which has indispensable component of aviation and space law, for which he secured as an A+. He has extensively published in all the branches of the law and is renowned adjunct professor in both Sri Lanka and overseas. Furthermore, he was also an adjunct professor at Lovely Professional University in India, with the both civil and criminal practices in the legal arena, and Justice Nawaz holds an around experience of the study and practice of the law. So I warm welcome on this platform, Honorable Justice Nawaz sir. Now I will just tell about Ms. Aishwarya Bhati, who is the Additional Solicitor General of India. So let me introduce, I warm welcome Ms. Aishwarya Bhati ma'am. Ms. Aishwarya Bhati has been a trailblazer litigator and she is the youngest woman advocate to be designated as a senior advocate by the Supreme Court of India. She also has the distinction of being one of the youngest Additional Solicitor General of India and being only the fourth woman to occupy this coveted position. Ms. Aishwarya Bhati has also persistently fought for the women's rights, children's rights, right of the person with the disabilities, and she has also been a crusader advocate of anti-tobacco litigation. She has led from the front and the right of the Women Office of Indian Air Force, Indian Army, and Indian Navy for the Act for consideration for the permanent commission and command position. She has been instrumental in the industry on the issue of the larger pictorial warming, plain packaging, and strong tobacco regulations. Furthermore, coming from the defense background, Aishwarya is the youngest of the three siblings and is flying high in the legal corridors. His father, K.S. Bhati, retired group captain of the Air Force, is also an advocate, and Aishwarya ma'am has considered her elder brother and Rajasthan High Court judge and Dr. Puspender Singh as her mentor. Her husband, Mr. Jaideep Singh, is also an advocate, whilst her father-in-law, Mr. Swami Singh, was a brigadier. Furthermore, to Ma'am Aishwarya Bhati, Ma'am Aishwarya Bhati has completed her schooling at the KV Air Force School, Jodhpur, in the year 1992. She pursued BSc from the KN College, GNV University, Jodhpur, from 1992 to 1995, and completed her graduation in the law from the Law Faculty, GNV University, Jodhpur, and later did her master in 1998-2000. Ms. Aishwarya Bhati, who was twice elevated as an honorary secretary in the Bar Association of the Supreme Court and was a gold medalist during the LLB. Not only this, she was selected for the Indo-Canadian Youth Exchange Program and represented India also. Further, Advocate Aishwarya Bhati has total professional standing of 22 years at the bar, and she was appointed as an additional Solicitor General of India by the Supreme Court on 30th June 2021. And was earlier designated as a senior advocate by the Supreme Court of India in March 2019. She was an advocate on record on the Supreme Court of India for 13 years prior to the designation as a Supreme Court. She was a former additional Advocate General for the state of Uttar Pradesh in the Supreme Court from 2017 to 2020. She was counsel for the High Court of Delhi in the Supreme Court, and she has been a panel lawyer of the Supreme Court Legal Services Committee, SCLSC, Supreme Court Middle Income Group Legal Aid Society, and amicus curiae, and she was Advocate General for the state of Uttar Pradesh. At the last, Ms. Aishwarya Bhati lobbied in the Supreme Court in the several major cases in the country, and she has conducted cases regularly before the National Green Tribunal, Delhi High Court, Central Administrative Tribunal, Armed Forces Tribunal, Consumer Courts, etc. The constitutional validity of the UID Aadhaar program has been challenged, and the number of important interim orders passed by the court. Constitutionality of the three religious practices, triple talaq, nikah, halala, and polygamy under the Muslim personal law has been challenged before the Supreme Court. In these cases, gender justice, gender equality, and gender freedom. So she has been appeared in the big matters at the Supreme Court. So I warm welcome over here Aishwarya Bhati madam on this virtual platform, and we have Honorable Justice AHMG Nawaz from the Supreme Court of Sri Lanka. So I warm welcome both the dignitaries. Now I just introduce our Pro Vice Chancellor, Mr. Dr. M.N. Patel, who is the Pro Vice Chancellor of the Parul University since the last 5 years, and before that he was the Chancellor at the Gujarat University. And sir, on this note, I warm welcome our M.N. Patel sir, and I request Dr. M.N. Patel sir to warm welcome our two dignitaries, which are the very renowned dignitaries at our Parul University. Over to you, sir. Sir, your voice is not audible. Hello. Excuse me, sir, your voice is not audible. M.N. Patel, sir. Ma'am, sorry, ma'am, I'm audible to you?
Yes, I'm sorry. I had some problem, but we can't hear Patel, sir. I can hear. I hope you can hear me now.
Dr. M.N. Patel, sir, I think your voice is, sir, can you unmute, sir? Okay, now I will tell our Dean, Dr. Namita Vyas Joshi, to warm welcome our both the speaker and address to our both the dignitaries, and warm welcome to both of them. To Dr. Namita Vyas Joshi, ma'am. Over to you.
Good morning to everyone. I hope I'm audible to all of you. Am I audible, Rajesh sir?
Yeah, ma'am.
Yes, ma'am, you are audible.
Thank you, ma'am. Good afternoon. Good morning to all of you. As myself, Dr. Namita Vyas, I'm working as a dean over here. And thank you, Rajesh sir, for giving me this opportunity to welcome to the layman sir. And really, at this time, I feel like extremely privileged and I'm honored that you've given me that opportunity to welcome to our chief guest, the Honorable Justice A.H.M.D. Nawaz sir, and my heartiest welcome to the Aishwarya Bhati ma'am, additional solicitor in Indian government. And thank you very much, ma'am and sir, to be a part of this webinar. And I hope that my students will learn much more things from your session. And again, another thing is that the topic that you have given to the Rajesh sir for to speak on that is the international arbitration. It is really a need of present days because if the all world is going to be globalized. Okay, so not only the thoughts and thinking are just transferring, as you all know that each and everything is transferring in a globalized way, and most of the time everything also is transferring. So it is a need to be that discuss on the topic that is international arbitrations and what the issues and the challenges we face during such kind of situations and the other things. So really, my heartfelt thank you all of you, to both of you that you are ready to discuss on this topic and you give the presentation on this topic. I welcome to both of you. Thank you very much.
Dr. M.N. Patel, sir, now you can speak, sir. No, it is not audible. Okay, no issue, sir. So we are handing this session on the topic of international arbitration to the Honorable Justice A.H.M.D. Nawaz from the Supreme Court of Sri Lanka. Over to you, sir.
Right. Thank you, Professor Rajesh. I hope that I'm audible to you.
Yes, sir.
Sir, you are audible to me.
Right. Okay. The connection from Sri Lanka seems to be very strong, right? Right. Okay.
Yes,
right. It's indeed a privilege to accept the invitation from Professor Rajesh to come before Parul University, and it's indeed my privilege that I have Professor M.N. Patel, Pro Vice Chancellor of the university, and Dr. Namita Vyas Joshi, the Dean. Both of them are on hand to receive both of us, the speakers for today. And I'm extremely thankful that of a day like this, I'm able to connect from here, the two countries which have very strong connections. I sometimes feel that the Cork Strait it may have been joined to the both countries at some stage. It may not have been there at all, and by some shift of the sea, we are separated, but then strongly connected. So now it's indeed my pleasure to share my screen. I have prepared something for today's lecture. So I'll concentrate on international commercial arbitration. Let me share this. Right. Do you see this? Right. Yes. Dr. Rajesh, do you see that?
Yes, sir, we can see your screen.
You can come see. Right. So now my task today, in the time that Professor Rajesh has allotted to me, is to raise some issues and then flag them for you. Right. Let me. Yes. Yeah. Right. Okay. So now, If you look at this arbitration, as the Dean of the Faculty has correctly stated, it is a timely province of the law in which all countries are today getting connected. There is this famous theory that globalization has taken place, and one reason why countries have been joined virtually as well as by various links is because of the international trade. Now, as international trade advances in its range and depth, so has the arbitration. And as everybody knows, both in India as well as so many countries of the world, traders, particularly people who engage in contracts, international contracts, engage in this. And if you look at the famous book on ICJ, right, chapter 1, it refers to arbitration as the oldest form of dispute resolution. And it has existed from time immemorial. I recently came across a book called Ancient Greek Arbitration. A famous professor, Derek Roebuck, has written, and he said, the ancient Greeks, the moment they entered into contracts and appointed arbitrators, they didn't bother as far as their awards or judgments were concerned, because automatically the people honored them. Otherwise, the wrath of Themis will take over all of them and punish them. Now, as you know, wrath of Themis, when he referred to wrath of Themis, it's really the goddess of justice whom he referred to. So there was this practice of ancient Greeks honoring their settlement and arbitral awards as of practice and habit. There was no need for courts to get involved. But today, with the passage of time, it is the courts that have now taken control of arbitral process in limited circumstances. And without courts, they say arbitration cannot exist, right? So now, as we go on, we will look at that. And now, well, I'm closely and acutely aware of the Arbitration and Conciliation Act 1996 of India, and I'm aware of the 2015 amendment and the 2019 amendment that were made to the Arbitration Act. And I have begun to look at the jurisprudence, but today I will confine myself to some international aspects when I present this presentation. But if you look at India, the pristine glory of arbitration could be seen, as some of these authors have demonstrated in this book that I bought recently, an oldish book, but it throws a lot of light on the Panchayat Raj in India, emerging trends across the states. In this book, they say virtually the Panchayat dispute resolution was a kind of arbitration, the informal nature of the proceedings. And even today, many villagers in Southern Asia view these kind of courts as informal adjudication by elders, family friends. And when you watch Indian films, you still see some of the Southern Indian films, you still see this informal adjudication having taken deep roots in India. So all these show that all the countries have ancient forms of arbitration which have today found itself in their legislative frameworks. So now there is this story which I love. Well, India gives us pristine stories of Ramayana, And there has been this battle between the sons and father, and there are even a range of Hindu deities was invoked to resolve the dispute between the sons and the father. This is what is recorded in that famous book written by P. Richmond, Many Ramayanas, Diversity of a Narrative Tradition in South Asia, which was published in 1991. So now this is history. Anyway, moving on to the modern forms of international commercial arbitration, you can see two kinds of trends. One is where some countries such as Switzerland, France, and Scotland have two different regimes, two different legislation to cater to domestic arbitration and international arbitration. So based on that classification of having two different regimes, they are sometimes classified as more liberal international arbitration countries by authors like Professor Mistelis. Then there are countries like the United Kingdom, India, and Sri Lanka. We have both domestic and international arbitration catered to in one legislation. Now, if you look at the Arbitration and Conciliation Act 1996, both the domestic and international arbitration, as far as the enforcement, and they are all covered in one legislation. The Sri Lankan legislation, Act number 11 of 1995, we were 1 year ahead of you in enacting our Arbitration Act number 11 of 1995. Even there, you have domestic and international arbitration dealt with in one legislation. And then if you look at international arbitration, I'm just flagging these issues, right, which will be of interest to students present today, right? Professor Rajesh said that lots of students are watching this, right? I'm just giving them a bird's eye view, right? It all starts, arbitration, it all starts through an arbitration agreement entered into between two parties or more parties, right? So that shows the party autonomy of the two parties. Then what they do in that arbitration agreement, they may include rules, right? They may include rules, they may include national laws, right? So now if you look at the one whole arbitration as an inverted pyramid, right? As in Egypt, you will see the arbitration agreement at the bottom. Then you have national laws of the countries. Now, if you look at Arbitration and Conciliation Act 1996, there is a national law which will be rooted to that arbitration if the seat is in India, right? And we both Sri Lanka and India have copied, or rather taken, the model law, UNCITRAL or UNCITRAL model law into our national laws. Then governing the arbitration agreement will also be international arbitration rules. Now, parties choose these rules, right? In other words, the arbitration agreement may contain the rules to govern arbitration. So international arbitration rules such as ICC, LCIA, the SIAC in Singapore, HKIAC rules in Hong Kong, ICDR, and even you can even permanent court of arbitration rules you can include. Then on top of it, I just must flag one more on top of international arbitration rule, that is the international practice, right? I'll refer to that. International practice also can be taken note of when there is an international arbitration taking place. Then you get on top of it international convention. The famous convention is the New York Convention 1958, right? Both Sri Lanka and India have ratified this convention. It's part of the both of our legal systems. So that convention in 1958 entered into in New York Convention. New York also governs arbitration agreement for two purposes. I'll refer to that later. Then the one that I showed you, this pyramid, inverted pyramid, really represents the regulatory web, right, of arbitration. At the bottom, arbitration agreement. Top of that, you get national laws. Then UNCITRAL has updated its rule. Then you get that 2010 rules now, right? Then all this flows from the party autonomy. Both parties can choose them, right? Both parties enter into arbitration agreements, right? It can be a submission agreement, right? Either of the two. So now, once again, I just put them for your clarification. The point that I'm trying to flag is this: the point that arbitration agreement will be regulated. That's why I call it a regulatory web, by all these 3 or 4 instruments that will surround the arbitration. Okay, right. Now, if you look at the national laws, there are 3 laws governing the agreement to arbitrate, laws governing the substance or merit of the dispute. The contract may be governed by the Indian law, right? The laws governing the agreement to arbitrate can also be governed by Indian law. But how about lex arbitri, laws governing the arbitral proceedings? That can be Arbitration and Conciliation Act 1996. So all 3 also can be governed by one single law, the national law, or you can also have several laws governing them. So you can have, law governing the substance or merit of the dispute. You can have it governed by English law if the British party has insisted on it, or the government, the law governing the agreement may be Indian law. Then laws governing the enforcement arbitral awards, which is very important, New York Convention 1958, that has been incorporated into Arbitration and Conciliation Act 1996, that will govern, right? We have transported them. India and Sri Lanka have just copied them, Article 5, right, into our respective legislation. That is arbitration, and that governs the enforcement of arbitral awards at the end of the arbitration. Okay, right. So now we have looked at all this, right? If you want to see how many countries have signed up to UNCITRAL, you can just go to that last website. I will send his slides to Mr. Professor Rajesh. He never sleeps
Yes,
without, he has always been behind me. I must tell you, to get my time there. He has been calling me at least 50 times. So it is his insistence that has seen me right through. And if not for him, I would be not making this presentation. So, right. So, so we have looked at that, right? Substantive law, maybe the Indian law. When you say substantive law, right, it can be chosen by the parties, the Indian party and the British party, or even 2 Indians, right? Domestic arbitration, right? They can choose Indian law to govern them, right? Okay, right. So there are rules. What if they have not chosen? Then sometimes the tribunal is given the power to determine them, right? So this is how national laws will be governing the arbitration. Then I also alluded to, in the course of my presentation, there are some international practices that arbitrators follow and practitioners follow, and all of us as practitioners have followed them. Some of these international practices are International Bar Association on the taking of evidence. So these rules, if you look at ICC rules, right, in addition to them, sometimes you are asked to follow, how do you present your evidence before an arbitrator, right? Is it oral evidence, or you just file witness statements, right? And tribunal, if it wants to call the witness, then you can have them summoned, right? Unlike a trial proper, which takes place according to Civil Procedure Code. Then you have the ethical rules contained in that ethics for international arbitrators. Then you have conflicts of interest guidelines. You have AAA and ABA Code of Ethics for arbitrators. So all these international practices can also be grafted onto the arbitration that would take place. Let me, right. So then, let me now get on to the arbitration practice. We have looked at it. Then international treaties. I have just spoken about the New York Convention, which entered into force in 1958, which was finalized in 1958. This governs the recognition and enforcement of foreign arbitral awards, a great piece of work by several nations. India has recognized it, grafted it onto its Arbitration and Conciliation Act 1996. Sri Lanka has done it into its Act number 11 of 1995. It enables an award entered into or declared in some country, right? It gives it portability. You can transport it from France, right, and have it enforced in Sri Lanka or India. It's all due to the New York Convention, right? This is the significance. The significance is both. If you look at this 1958 convention, it governs both arbitration agreements and arbitral award. That's the beauty of it, right? Both it's a pro-arbitration treaty. When you sign up to it as a country, you have to have a pro-arbitration approach. As regards arbitration agreement, courts must be very slow to declare arbitration agreement null and void. Court must have a minimal approach as far as arbitral award is concerned. This is the spirit of New York Convention. So when we incorporate them into our legislation, we have to display that spirit in our legislation. But there are problems. There are times when arbitration agreements and arbitral awards do get impeached or impugned in national courts. If you look at this phenomenal case, well known in India, Renusaga Power Company's case, of course, I couldn't get the Indian citation. Maybe I need more time to look at Manupatra or SEC online to get it, but it is reported in Yearbook of Commercial Arbitration in 1995. In this case, there was this pronouncement made by the Indian Supreme Court. The purpose of this convention, this was in reference to the 1958 convention. They said the purpose of this convention was to widen the scope of the Geneva Protocol of 1923. What is this Geneva Protocol of 1923 that the Indian Supreme Court was speaking of? Right. Geneva Conventions, there were two, one in 1923 and the other 1927. See how the Indian Supreme Court was alive to this, right? This shows that India has had arbitration dating from a very long time, right? 1923 and even beyond that. Then both conventions, one dealt with arbitration clauses, the first one. The second one dealt with execution of foreign awards, right? You can see these two conventions dealt with arbitration agreements and awards, but the New York Convention today deals with both of them. That is why Indian Supreme Court in Renusaga said, right, this particular treaty, New York Convention, has widened the scope of enforcement and arbitral agreement. Okay, this is a bit of a history that there are other international treaties. I'm only now, if you look at it, I'm going in a logical manner. I was looking at the arbitration agreement. I was speaking of the national laws. I was speaking of international practices. I'm really structuring it on the basis of that inverted pyramid, right? One by one, I'm chipping into them, right? Okay, and then at the top, you would have seen international treaty at that. So then I'm on that part of, I'm at the top of that pyramid, rather, right? So what are the other treaties that are there, both multilateral and bilateral? There is this 1975 Panama Convention, right? Even the United States has incorporated this into their Federal Arbitration Act, Inter-American Convention on International Commercial Arbitration. Latin American countries are parties to this. Then you have this European Convention, 1961. Then you have this famous Washington Convention on the Settlement of Investment Disputes between states and nationals of other states, 1965. Very few cases those days. I think if you look at some of the literature on the provenance and the beginnings of this ICSID Convention, the Washington Convention, right, it deals with settlement of investment disputes. You would see Sri Lanka. Sri Lanka's settlement dispute, one such dispute was the first case that originated under this legislation, right? Sri Lanka had a case going up before arbitrators, an investment dispute that begins AARP, just Google it, right? That particular, that was the first. Now today, the number has grown exponentially, right? That shows how investment disputes also have taken us by storm. Then you have the Arab countries, Amman Arab Convention on Commercial Arbitration in 1987. They too have concluded international treaties among themselves, right? Okay. Then this, once again, you will have copies of this, right? The ICSID Convention. So now, once again, let me summarize the regulatory web that surrounds an arbitration. These are private agreements, arbitration agreements, signifying party autonomy, agreed upon rules. You can agree on rules, party autonomy. Once again, parties choose it. National laws, parties may choose. International practice can engulf you. International conventions, automatically, because of your country's accession, they govern you. So within this regulatory web, an arbitration takes place. Okay, I have just put them into this. Then Professor Rajesh said,
Yes, sir.
look at some issues and challenges. Okay, right? Now, why did arbitration emerge as an alternative mode of or dispute resolution method? Because we wanted to cut on the cost in courts. The long delay that ensues in court has to be minimized. It's on account of that we have arbitration procedure taking over us. So if that is the motive, if that is the purpose, there are some issues that will curb that progress. It has been doing so in the past. Our courts are flooded with them, and then so we have to be very careful, right? When you deal with these issues, right? These issues can surround, of course, you can talk for hours on these, right? You can talk on this for days, but let me flag only some of them. Let's look at arbitration agreements. Particularly, you have to be extremely careful, as everybody knows, right? How your arbitration agreement must be drafted. There are some arbitration agreements which become pathological. In other words, they virtually die along the way. So you should not draft clauses which are which can be rendered sick, which can be rendered ineffective, right? So if you agree to arbitrate, your arbitration clause has to be drafted effectively, right? So now Sri Lanka had a case some time ago, which is well known in this country, right? You can even Google it. A case called Elgitred, ELGITREAD versus Bino Tires. Bino, ABINO. Right? The moment you Google it, you will get that case. That was a pathological clause. Parties said, we will have an arbitration, but they said, Chamber of Commerce, we will have it, a Chamber of Commerce. We will refer this to a Chamber of Commerce in Sri Lanka for arbitration. There are chambers of commerce here, but none of them get involved in international commercial arbitration. In other words, at the time when this arbitration clause was drafted or put into the contract, this institution did not exist, right? Non-existent institution was put into the arbitral clause. Luckily, what happened? One of the parties who got disappointed with the other party never went for arbitration. Straight off, they filed a court action. When it filed a court litigation, the defendant took the objection. Well, you have an arbitration clause. We must go for arbitration. Court is not the forum. But the plaintiff argued, no, I won't go to, because the clause, even though I agreed to this clause, it is pathological. It is ineffective, because both of us have agreed to an non-existent institution. We can't refer this to an institution which doesn't exist. So therefore, this clause has died. So we have to fight this dispute in the district court or the commercial high court of this country. So when that was taken, objection was taken, that case went all the way to the Supreme Court of this country, right? And the Supreme Court of Sri Lanka gave an arbitration-friendly judgment in line with Neo Convention and ancestral model law. They said, well, even though you have said that you should refer this to a non-existing institution, your intention is to arbitrate. We can see that you have agreed on an arbitration clause. Your intention is to arbitrate, and therefore you should arbitrate. They refer the parties to arbitration, Supreme Court. So pathological clauses, mind you, are clauses that can delay your arbitration. You have to be very extremely careful on a technical issue. The matter went all the way to the Supreme Court. Undue delay was caused, but finally the Supreme Court put it right and then said, told the parties, get back to arbitration. So this is the challenge. This is the issue. So drafting of your arbitration agreements have to be perfect. And then they have said, if you want to have an effective arbitration agreement, the characteristics have to be 9, 8, sometimes 9, 10 in number, right? Far better for you to be very clear. It has to be a valid and unambiguous arbitration agreement. It far better for you to specify the seat, right? There is this problem in the Indian Arbitration Act, Arbitration and Conciliation Act 1996, but I won't call it a problem. Right, section 2, I believe, right, section 2 says this part 1 will apply where the place of arbitration is in India. Place of arbitration, it uses the word place of arbitration, right? But the courts have now cleared that issue, right? I don't think that it needs an amendment. They have said seat is the juridical place of arbitration. In other words, it will govern. The moment you specify your seat, it's going to govern your interim relief, right? It's going to govern your arbitration agreement. So, but the place of arbitration can vary from place to place. At the moment you fix it to a state, India, you can have it in Bombay, you can have it in Chandigarh, you can have it in, you can move your arbitration within the country, right? So as long as the seat of arbitration is India. But far better for you to use the word seat. It's far better because unfortunately, I must say, sometimes some of these arbitral clauses are called midnight clauses, right? Champagne clauses. You do it quite late in the night, right? After drafting your contract, which runs into about 15, 16 pages, when you come to the arbitration agreement, you don't pay attention. What do? You just miss out on these things. As a result, this breeds a lot of litigation, resulting in inordinate delays, right? So that's why it is always said, specify the law governing the arbitration agreement, specify the law governing the law of contract, right? Specify the qualification. You must address the language of the proceedings, what institutional rules will apply, and if you need confidentiality, specify that, right? And it must be tailored to the needs of the parties. And if it is a multi-tier arbitration, in other words, you go for mediation first, and then you have to be quite clear on these issues. So now there's a large slew of cases on the clear arbitration clauses. Now look at this case, Krupa versus Bernati and Ono, 2014, decided in London, right? Now the parties said, we will endeavor to resolve the dispute through arbitration. The question arose whether this kind of clause is really an arbitration clause, right? It arises in Sri Lanka sometimes, right? So now look at the way the arbitration clause was drafted. This was how it was drafted. They said law of England and Wales, that's all. They should have said the governing law should be the law of England and Wales, right? Then they said, in the event of any dispute between the parties, pursuant to this agreement, the parties will endeavor to first resolve the matter through Swiss arbitration. Should a resolution not be forthcoming, the courts of England shall have non-exclusive jurisdiction, right? Now what happened? A court case was filed, right? The plaintiff, the defendant said, no, you can't file a litigation in this. It has to go for arbitration. But the court, the English court said, look at your arbitration clause. It is so ambiguous. It is not clear. You are only saying we'll try to resolve this matter. You are not very clear on arbitration. So don't use language like this. This is how the Court of Appeal in Krupa versus Bernati and Ano said in 2014. So that's one area you have to, it's a challenge. It's an issue that crops up all the time. Then another issue is about the seat of arbitration. I already talked about it. Now, you have to mention that you have to be very clear about it because if the seat is India, it is from the Indian courts you're going to get your interim relief. So you're right, there are various stages at which you can go and seek interim relief, right? So now, say if the defendant is trying to send money out of the country, right? So you can ask for freezing injunction on the defendant or the respondent. You are the claimant, right? So if you want to get from your local courts, the Indian courts or the Sri Lankan courts, interim relief, right? You must tie the arbitration to a seat, right? So all this is very, very important as far as seat is concerned. A case that illustrates this is a case called C versus D, right? Decided in the United Kingdom in 2007. Now, it was an insurance contract. They said arbitration must take place in London. In other words, seat was in London, right? Governing law, in other words, the governing law that must govern the dispute for resolution is New York law, they said. Okay, New York law. So, as I said before, the governing law and the underlying contract, the seat law may be different, right? Okay, right. Now, what happened? There was an injunction, right? After the award was given, what happened? The insurers lost this arbitration. So what they did, they lost it in the United Kingdom. Arbitration took place in the United Kingdom. The arbitrators were seated in the United Kingdom. So they awarded the successful money award in favor of the claimant. The defendant insurers, what they did, they took the arbitral award. They tried to do it in New York. They tried to challenge it in New York. What happened? The claimant stopped them by getting an injunction. And it was decided by the Court of Appeal in England, if you choose London as the seat of arbitration, you should remember that proceedings on the award, in other words, after the arbitration is over, the proceeding must take place in the United Kingdom. This was how C versus D decided. So now, why was this delay happening in this court? Why did this happen? All because the draftsman of this clause did not mention the law governing the arbitration agreement. If they had just said, the law governing the arbitration agreement is UK law, all these problems would have been averted, right? Because you didn't do it, finally it has to end up in the Court of Appeal. This is how delay takes place. These are issues. These are challenges, right? These things take place not only in the United Kingdom, it takes place in Sri Lanka, it takes place in India. So one has to come. So I think, Professor Rajesh, I may be exceeding the time limit that you have given me, right?
Okay,
But
okay, no issue.
yeah,
No issue. Madam has some conference, so means
okay.
after, because I have to inform her that her conference is also going on.
All right. Okay.
Yeah.
Then I can go ahead. You are saying, is it right? Right. So now look at some badly drafted clauses. I just wanted to show them. Right. Now, if you just put English law dash arbitration, if any, arbitration if any, London, according to ICC rules. Now look at this arbitration clause, a deficient and insufficient arbitration clause. Now, this kind of arbitration clause really occurred in this famous case of Arab African Energy Corporation Limited, reported in 1983 to Lloyd's Report 419, right? Now, if any, court pointed out, really doesn't clearly impose an obligation on the parties to arbitrate the disputes. In other words, you can always argue that it is court proceedings that must be started on this dispute rather than arbitration proceedings. So, court said in this case, this kind of arbitral clauses must be avoided, must be averted. Now look at clause 2. In case of dispute, the parties undertake to submit to arbitration, but in case of litigation, the Tribunal de la Seine, it's in Paris, right? Seine River, right? Shall have exclusive jurisdiction. Now look at the ambiguous nature of this clause. It's so doubtful, right? Quite unclear, right? Whether the parties are obliged to arbitrate or not. Both options are given, right? And now the draftsman who drafted it didn't know to put an obligation on the parties to go for arbitration. So both obligations are given. So this kind of it leads to ambiguity, resulting in inordinate delays. So these are some of the challenges. As I said before, these are also called pathological clauses. Some courts will rectify them. Some courts may strike them down, right? And then order the court to take over the case and continue. So now there is no uniformity, I must tell you, between national courts as far as these clauses are concerned, right? There's no uniformity, right? So now ICC, International Chamber of Commerce, now which is located in Paris, they have come out with a model ICC clause, right? I'll send this slide to Professor Rajesh. You can distribute it to
Yes, sir. Yes, sir.
whoever wants it.
I
Then,
will circulate to my students also.
of course, you should do that.
Yes, sir.
Then look at how a US case where the Federal District Court have said, if you use the phrase arising hereunder, it is a narrow arbitration clause because it is restricted to only disputes and controversies relating to the interpretation of the contract and matters of performance, right, of that particular contract. So it's only restricted to the contractual disputes there, right? So if you adopt arbitration clauses such as this, it is quite narrow. And let's say, for instance, you can't come and argue on this arbitration clause. You can't come and argue, well, I signed this arbitration clause, right, under fraud, because the arbitration tribunal, you can't take an objection to this because the arbitration tribunal has been told that you can only go into claims arising under this particular contract. But that is why there is an obligation on lawyers, draftsmen, practitioners to broadly couch the arbitration clauses, right? You don't narrow it, right? You must broadly couch the arbitration. There are some other issues that can arise in multi-party arbitration. There may be several parties to one contract. Say a building, Parul University wants to put up a building. So it may give it to a contract, right? There may be one contract. Yeah, the contractor may have another contract, a subcontract, and that subcontract may have another subcontract. So there are one contract you may have, but there may be various parties to these contracts. Can you bring them all together, right? There may be several contracts with different parties, right? So can they argue, right, we are only parties to the main contract? We are not, so can the other people, subcontractors, can they argue, well, because we are not parties to the main contract, we can't be brought into the arbitration? Well, there is a lot of literature on this, right? If contracting parties are intrinsically interwoven in the main contract, in other words, even though there are subcontracts, if all those subcontracts can be brought together as if they are also parties to the main contract, even they could be taken before arbitration in one arbitration. In other words, the point that I'm trying to tell you is even a non-signatory to the main contract can be deemed to have signed up to the main contract, and you can bring them. So those are called consolidation, right? You can make consolidation by consent, right? These are all So you must draft your arbitration clause in such a way that even a subcontractor can be brought in, right? And there are class arbitrations that have developed today, right? One class can commence arbitrations. So I have dealt with this, how you, the factors that you have got to consider while drafting an arbitration agreement. These are some of the issues. And if possible, you can even refer to interim relief, right, in your arbitration clause. Now there are so many arbitration clauses. They don't speak about interim relief. Right? No doubt, you can get interim relief before the arbitrators, but can you get interim relief prior to the constitution of the arbitral tribunal? Well, Indian courts have said you can. Sri Lankan courts have said you can, right? So, but far better for you to have interim relief clauses in order to erase or eliminate any kind of ambiguity. Now, say for instance, take the case of a plane that comes to India. Okay, a plane comes to India. Now you have so many aircrafts, right? So many aircraft lines. Say a national airline comes to India. Now, take the case of a British party which has leased out that plane to the Indian airline, or which has leased out. No, let's not talk about an Indian airline. The airline is some other Paris. It's a French airline, we'll say, but the plane was leased out to the French airline by the UK producer of the aircraft. The aircraft company finds lease rentals on the plane are not being paid. Okay, so can they come to India? The aircraft company is located in the United Kingdom, right? The Paris company, which has taken the plane on lease, has not been paying the rentals. The plane comes to India, right? Can you come and seize the plane in India, right? Can the airline argue before the Indian courts? The seat of arbitration is in Singapore, right? The Indian courts have no jurisdiction, right? But we have gone to the extent of holding that Indian courts have jurisdiction, right? You come long before the arbitrators are constituted in Singapore, you can still get your interim relief, right, in a country which is not the seat of arbitration. So if you have this kind of complex contracts, it's far better for you, in order to clear any kind of doubts, to lay down interim relief and things like that in your arbitral agreement. That is why it's far better for you to draft an unambiguous arbitral clause, right? So this is all that I wanted to say, Mr. Rajesh, Professor, right? There are some more things that I wanted to talk about. I'll come round and then
Sir, if we can give chance to ma'am, because she's also waiting.
Yeah, of course. You have to give it to her, right?
Yeah.
And then if I'm going to touch on this, I'm going to take another 1 hour, right? So
yeah.
I'm not going to right. So thank you very much. And I hope.
Yes, just a minute. Sir, shall I hand over to Aishwarya Bhati ma'am?
Of course, you can.
Yeah.
You can.
Yes, so a very good afternoon, to all of you. Now, very good morning to all of you. I am Dr. Rajesh. Now I am handing this session to Aishwarya Bhati, who is the Additional Solicitor General and the topmost advocate from the Supreme Court of India. Aishwarya Bhati ma'am. Sir, can you just close this, just a minute. Honorable sir, can you just close?
Oh, yeah, I'll close it. I'll close it. Yeah, close it. I'll stop sharing it. Yeah, okay, right, okay.
Just a minute. I'm just calling. So just she's joining in 2 minutes.
Good morning again, and sorry, I was I can't hear you, Dr. Rajesh. Can you hear me? आप muted हैं शायद.
Yes, ma'am. Yes, ma'am.
So I apologize again to everyone. I heard the address of Honorable Justice Nawaz for some time, but unfortunately I had to jump into another conference that I had.
Yeah.
So I'm just going to share some of my thoughts and views. It is, of course, indeed a great privilege and honor for me to be here to discuss these important issues. The panel speaker, Justice Nawaz, has taken the participants and the students through the very detailed PowerPoint presentation, and I understand he's going to share it with you all so that that's very comprehensive. I think there's a paucity of time also, and I'm just going to, there's no point in repetition, so I'm just going to focus on the core aspect of what, in my opinion, are the issues and challenges which are affecting the international arbitration platform as of as we speak, as of today. I think before we go on to the main topic, there's one or two caveats that I definitely want to start with. If you look at the volume, the total quantum of where the international commercial arbitration, investment arbitration, all kinds of international arbitration has arrived today in 2022, then it's, often when we look at the problems in today's context and right now, then we do not appreciate the journey that has been undertaken in the last 40, 50 years for arbitration. See, our world has gone from traditional dispute resolution where, where different forms of government, different forms of democracies, different forms of governance and states, they all fell in line, and they had their own domestic dispute redressal mechanism. And a need was felt that the traditional court system is not well suited or best suited for resolution of disputes which may have international ramifications, cross-border, cross-country impacts and jurisdictions, because the culture, the traditional system of every country is bound to be different. So when we talk specifically with regard to international arbitration, it is a long journey that the world has undertaken in the last 50 years. Going when we started, it was the individual countries' arbitration laws that were governing those. There was no uniformity, there were no standard set practices. there were no international best practices when we started this journey. But in the decades of 1990s specifically, there was a lot of work that happened. Justice Nawaz has already taken you through the detail. I'm just recapping for the purpose of realizing what a journey we have undertaken. So from there to have set, uniform patterns, uniform UN-approved trade laws, UN-approved procedures. There are at least 3 very robust and dynamic international arbitration centers that are well recognized in the world. These are countries which have provided ecosystem, which is the best ecosystem available for dispute resolution. And the volume and the quantum of international arbitration from where it has grown in 2022 from the last 50 years itself shows that this is a system that has worked. This is a system that has inspired confidence of the parties at the dispute. This is a system which has a very bright future. And in fact, I think there is no other system that can really rival the system or, in any manner substitute the system. So our sole choice lies in whatever are the problems and issues that are continuous. Now, life goes on. Problems and issues go on with life. It is not like problems and issues are going to be finished. They are going to, we'll sort out the problems, we'll find solutions to problems, and there'll be new problems that we'll be facing. The world at several stages felt that international arbitration, there were question marks on several important world deadlines or datelines that happened. Brexit raised lots of eyebrows that whether, what is going to be the impact of Brexit on the international arbitration. Singapore, of course, has developed as a very strong and robust ecosystem for international arbitrations, and that is why you see a large quantum of international arbitrations going there. But a COVID-19 situation or a pandemic, looming over the world, or problems and civil wars in different pockets of the world, how that is going to impact. I think this is a system that has proven itself. It has found solutions. It has become more dynamic, more robust, and it has sort of proven itself in a manner that it is the most efficient system that is available. Now, there is something that our Chief Justice said just 2 days back, and the forum that he was speaking was a conference in London on arbitrating Indo-UK commercial disputes. And I think I certainly want to quote what he said. This is a statement he made on 5th of July. And he says that arbitration is the best suited dispute resolution mechanism for the commercial world. It is an effective alternative to traditional litigation and is regulated primarily by the terms previously agreed upon between the parties themselves. The process is consensual, confidential, and the result is binding. Now, and then he recognized the aspect of how India has also developed as a country, which inspires a lot of confidence between the litigating parties, between parties who get into a dispute. Like Justice Nawaz had explained to you at length that, autonomy is the core of an international arbitration. Any arbitration for that matter, but international arbitration all the more, because the party autonomies, the parties to the agreement, they can choose what laws will apply to their arbitration, in what manner their future disputes will be sorted, what will be the seat of arbitration, which forum will apply, what will be the cost, etc. So that the whole mechanism is already evolved well before the dispute, and party autonomy is really the core of this. So to recognize that Indian system of judiciary supplements and complements very well to the international arbitrations for 2 reasons primarily. One, India has a robust mechanism of rule of law. Our judicial systems and institutions inspire confidence world over. We are a stable and robust democracy, which do not have the problems that many other countries have of any disruptions or anything boiling over or anything interruptions in any manner of governance. So the parliamentary democracy We don't have the system, of any disruption or interruption in a manner that there's a continuous governance, even when there is change of power. And secondly, our courts have now become exceedingly cautious and conscious of the fact, and that reflected in the Chief Justice's speech also day before yesterday. Chief Justice Ramanna very categorically said that the Indian judiciary is very cautious of its role in the arbitration process, that their role is merely supervisory. Their role is only of assistance and not interference. So that is a very important aspect. These are two important aspects that allow a very robust ecosystem to flourish in India. I think when we talk about challenges, I think the biggest challenge really to international arbitrations, to my mind, as I see it, is one is the inequality between the dispute, to the parties to the contract, the parties to the dispute. Because if there are companies who are arriving at at an arbitration clause in their contract, it is not always that the two sides are going to be on an equal pedestal. There will be one party to the dispute that may be a multi-billion-dollar company operating out of countries that have tax immunities and much more immunities, operating out of developed countries where the cost of living, etc., is very high. And there may be another limb or another arm to the contract, where the company is not financially so big. It already is operating in the constraints of a democratic world, or a constraints of the country that the domestic laws that it operates in. And then like, for example, when we buy a railway ticket, essentially that ticket is a contract. I'm just giving a small example. Of course, it has no international ramifications, but we as a passenger are in no capacity to alter the terms of that contract. Or it's a standard contract that exists. If you want the ticket, you take it and you move on. So this inequality also exists between parties when they're arriving at international contracts which have arbitration clauses. And this inequality further gets aggravated when the dispute resolution process starts. The cost for one of international arbitrations is exorbitant. Now, this becomes even more exorbitant if one of the companies is operating from a developing country, where the currency that they operate in, there is a huge difference in that currency, the legal costs, the cost of arbitrations, the council's costs, etc. It becomes exorbitant. So I think this is one area that we really need to focus on, so that the inequality between the parties can be bridged in a proper manner. Secondly, to my mind, the ecosystem that needs to be there needs to be a favorable ecosystem. That ecosystem has to allow interim orders, the law of the land, etc., also to rule, because international arbitration should not become a mechanism or a tool for oppression from one side at the hands of others. I want to give you one example of a recent case that was in a lot of we discussed. It was in a lot of discussion recently in India, at least. That was the Antrix Devas agreement. You are all aware that Antrix was that arm of ISRO, the Indian Space Research Organization, and they had that agreement with Devas for the S spectrum. It ran into trouble because there was a lot of problems to start with. That S spectrum itself was a spectrum that was used exclusively for very specific satellite, etc., domain expert areas. And there were 2 international arbitration awards that had been passed against Antrix, and sovereign assets of the government of India were sought to be attached in execution proceedings by some courts in Canada in pursuance of execution of those international arbitration awards. Then this recent judgment came just 2-3 months back. The Indian Supreme Court affirmed the judgment of the NCLAT, approving the liquidation of the firm on the ground that there was malice in law. To start with, this deal was effectuated by malice in law. It was done with the whole purpose of having undue gains, there was malified in it, and therefore that malice in law affects a nullity, and therefore that liquidation order was affirmed. So I think this actually raises another red flag, that if by way of a contract, some public policy, some rule of law is sought to be curtailed. Now, sovereign assets of our country means these are assets of the exchequer. These are assets of not just the exchequer, but the citizens of the country. If that would have been unfairly treated by virtue of an international arbitration award, then that would have nullified the very essence of the rule of law that we exist in. So this was one aspect which I felt was an important aspect. To my mind, now the issues of uniformity, the issues of autonomy are much better affected, much better taken care of. And if we are able to curtail the ecosystem and the inequality between between developing and developed world, and the aspect of not diluting the basic concepts of our human existence, our basic human laws, our basic public policies, then I think there is no problem there. Of course, India's system is very robust. There are several international arbitrations that are going on between Indian companies. Several of them are going on in India. Of course, London and Singapore remains the hottest favorite for the ecosystem that it has developed. And I think the biggest gain, while I talk about these two big challenges, I certainly also want to highlight one very important gain that the pandemic has given to us. Our world has not come crashing down. Unlike what the doomsday predictors were saying, that this is going to be, end of the world as we know it. The world is far more robust. We just need to take care of our Mother Earth a little better, and I think we will be able to tide over any other challenge. Of course, if we don't take care of our Mother Earth, then there is no challenge that we will be able to meet. But we will be able to find every other solution. Mother Earth is one aspect of our existence that we cannot ignore. And the second aspect is technology has made everything possible. Today, we had the privilege and the honor of listening to such a renowned judge of the Supreme Court of Sri Lanka. I mean, interestingly, he mentioned that also in the morning when all of us were having connectivity problems. His Lordship Honorable Justice Nawaz had no problem in connecting with Sri Lanka, and we've had the benefit of his views, his thorough, comprehensive, meticulously prepared presentation. He's really, it has been a very informative lecture to hear him. Unfortunately, I had to run in between, but I will also take from Professor Singh the PPT copy of the lecture of Honorable Justice Nawaz.
Yes,
so we
sure.
get benefited. Thank you very much for allowing me this opportunity to share some of my thoughts. It's a great honor and privilege. I wish all the students of Parul University lots of luck, lots of success, lots of joys. Please enjoy what you're doing, because if you have to do this for the rest of your life, law is not a subject that is going to leave you easily. If you have chosen law, then you must enjoy the subject to its totality. And the only way to enjoy a subject is throw yourself into it. You can't, law is not a profession that you can do just with your brain. Law is a profession that will take your heart, that will take all of your soul, it will take everything that you can offer. Subject that will take all your hair, all your nails, all your body parts, your kidneys, lungs, your everything that you can think of. I'm not a science student, so not too many organs come to me easily, but throw yourself into law, then it will be even more enjoyable. All the best to everyone.
Dr. Rajesh, now I've changed my device in. I am now audible to you, rather.
Yeah, sir. So now I will just ask our Vice Chancellor,
my laptop,
Mr. Dr. M.N. Patel,
my
sir.
speaker is open, but my voice was not coming to you.
Yeah.
I changed that another device.
Okay, sir. Now I will tell Dr. M.N. Patel, sir, to say and express his views on this particular lecture.
Really, I'm very happy to hearing both the expert, especially Honorable Judge Sir has told a lot of things which I also learned, because I'm not the man of law, but I'm learning through this type of webinar. And as so far, Madam has said, Shura Bharti, that there is no problem connectivity at Sri Lanka. But we also don't have the connectivity problem. Problem is with the device. And sometimes this we have to bear with. But we have to thank this digital campaign that we are able to connect the person sitting anywhere across the globe. And we are taking a lot of advantage of that. Otherwise, what we are teaching to our law student may be a small bucket of water from the ocean. And knowledge is like an ocean and that can only be possible where we are getting the expert like from all across the various parts of the country or rather across the globe. And today we are lucky enough that we have Honorable Justice HMD Mr. Nawaz, as he has told about a lot of good things which I have also heard. Madam Aishwarya Bhatiji, she also told a lot of things. And really, I am very much happy to especially the Institute of Law, where we are arranging this type of webinar at least one in a week. And our students are the great beneficiary, and credit goes to Dr. Rajesh. And we hope so that in future also, we have such a lot of more programs. As so far Sri Lanka is concerned, we have another project of University of Surrey, London, where Professor Ravi Silvaji is a professor there, and he is with us on our third project of RAE, Royal Academy of Engineering, where we are working on the smart cities. So like that, we are the beneficiary of international speakers. And today in a law, we have got both the speakers are of a high level. And obviously, our students are the great beneficiary. Hope so that in future also, our association will continue. And again, I welcome you both because in the beginning, I could not join and could not welcome you. But now I will welcome both the speaker and expert as we have got the benefit of your talks. Thank you very much. Over to Rajesh.
Thank you, Dr. M.N. Patel, sir. It is a great privilege that that you are with us, sir, and you're always with us whenever our college requires. You are there with us. So now we have certain question answer session. So the first question to Honorable Justice AHMD Nawaz, sir. Sir, the question of the student is, do you think that with so many procedurals and rule of arbitration has also become overly complicated and rule bound? Sir, over to you, sir.
Well, it all, yeah, there are rules that have been developed by institutions, right? Because it's not litigation centric. You must remember it is if you have rules, well, you are not going to choose so many rules. There'll be only one rule, right? You will choose, right? But there are so many rules to choose from. Now, say ICC rules, UNCITRAL rules, right? LCIA rules, SIAC rules. Well, it all depends on what kind of expeditious inquiry or arbitration you wish to conduct, right? So if you look at the rules, you will see all of them aim at expeditious disposal of your case. And if you look at the court cases, you are bound by the civil procedure code, right? If you go to court, you will be bound by the rules postulated in the national laws of the country. But if you go for an international commercial arbitration, right, the parties are the ones who choose. You don't choose too many rules, only one particular set of rules. So all the rules have the aim of expediting and finishing the cases or the inquiries or the dispute resolution methods on time, faster. If you look at ICC rules, right, you have to work according to the rules, right? You can't be obtaining time. Now, if you go to court, you will obtain time and then extension is granted. But here, extension will be granted only on payment of cost. So the rules are very cost effective, right? So I think more the merrier in my view. You see, more rules that are there, it has not complicated the arbitral procedure, right?
Sir, we have another question, sir. As per the seat is concerned, so if
Yes.
there is a dispute that the seat is not there is a question that at which place that particular arbitration matter should be taken care. So in that case, sir, what is the procedure in international arbitration, that how the seat is to be decided? Because as per the agreement in the arbitration clause, there is an in an agreement there is an arbitration clause. And
Yeah.
if suppose the seat has not been mentioned, so where how this arbitration award can be defined and how it can be taken care, sir?
No, I think it is, the seat of arbitration, right? I said it's very important for several reasons. Number one, arbitrators, as I said before, can't exist without courts, without national courts. So you have to sit in one country or in one. So when you sit in one country, right? When you tie it to now, even if you say arbitration will take place in London, so it can't take place in Utopia, it can't take place in Esgardia, in Spain, right? The arbitration, if you say arbitration shall take place in Singapore, the seat is Singapore. Then if one of the parties wants to get an injunction, right, interim relief, right, say they are trying to dissipate, the respondent is trying to dissipate the assets, right? You have to get security, right? Where do you go? So seat is easy to locate, right? So the only thing is, if you don't mention the seat in your arbitral clause, but by merely saying that the arbitration shall take place in India, that means the seat is India, right? Then you have to go to Indian courts for interim relief. So you have to, far better for you to specify the seat, right? But even if you don't specify, it's implied, right? Right? Okay.
Yes, sir. Sir, one another question. Sir, what is the key development needed to make the arbitration as preferred the method of the dispute resolution, sir?
The key developments are, right, you have to be up to date with what is good for you, right? You have to be up to date with the rules, right? Because you come for arbitration because you don't believe in the efficacy of the dispute resolution through courts. You just want to save time. You just want to save cost, right? So then you have to choose. There are two types of arbitration, Professor Rajesh. One is
Yes,
ad hoc arbitration and
Yes.
institutional arbitration,
Yes.
right? Yeah. So if in institutional arbitration, an institution will be behind you all the time,
Yes,
right?
sir.
Telling you, right, file your defense on this day. If you don't file, so ICC. So would you like to go for that, or you just want to follow an ad hoc arbitration governed by UNCITRAL rules? It depends on which rule you want to adopt. Right.
Aishwarya ma'am, are you there? Aishwarya ma'am. Okay. Sir, I have the last question. Do you think with so many procedures and the rules, arbitration has become overly complicated and rules bound? Honorable Justice Nawaz, sir.
I don't think that it has become complicated, right?
Well, it is going
It
to
all
be
depends
settled.
on the framework within which you work, right? You can make it effective, right?
Yes, sir.
If you have the right temperament, to make it effective, right? Right.
Sir, it was very fantastic session by you, sir, and we required that particular PPT. It was very fantastic one, and really, Aishwarya madam has also elaborated in a very systematic way. So really, our student have learned a lot, and we have our co-vice chancellor, sir, who has also there with us whenever we took any parts of this event. He is always there to keen to interest, and entire session he was listening with the so many workload on him. So I really appreciate Honorable Justice AHMD Nawaz and the Additional Solicitor General of India, Ms. Aishwarya Bhati ma'am. On this note, now I will give this session to Mr. Gagneet Singh, who is the coordinator in this program, to give a vote of thanks. Over to Gagneet. Gagneet, are you there? Okay. So now I will give the vote of thanks. So on the behalf of Parul Institute of Law, Parul University, and on the behalf of Dr. Namita Vyas ma'am, I am thankful to both the dignitaries who has given this given the valuable time to our university. And on this note, I am thankful to both of you. So, Honorable Justice, I am really thankful to you, sir, and Miss Aishwarya Bhati madam. So on this note, we are closing this session. It was very fantastic session by both of you. So now I am also thankful to Brijesh Kubhani sir, who has given this live coverage, and we are very much thankful to the entire team of the Parul Institute of Law. Thanks a lot for your kindness, sir.
Thank
So
you.
we are closing this session.
Thank you.
Oblige, sir. Oblige. Brijesh sir, you can stop this live coverage. Brijesh sir. Hello, Brijesh sir.